I'm Jeff Butler of the Butler Law Firm, and today we'll talk about the statute of limitations in personal injury cases. The statute of limitations is just a fancy legal word that basically means deadline. It covers the amount of time you have until a case has to be filed. In Georgia, in personal injury cases, the general rule is that personal injury cases have to be filed within 2 years. That comes from OCGA, or the official code of Georgia annotated, section 9-3-33, which you can look up on Google. And if you do, you'll find that it says that, quote, injuries to the person, end quote, meaning personal injuries, have to be filed within 2 years. Now that means filed in court, like real court, like a case, going to be litigated, go to trial kind of thing. Having the case filed as a claim with an insurance company within 2 years doesn't help you. It has to, if you're going to bring the case and succeed and go forward, it has to be filed with the court within 2 years. Of course, some cases settle before that, but 2 years is the deadline to get the thing filed in court. Now, it's often said that a new lawyer knows the rule, but a good lawyer knows the exceptions. So we'll talk about some of the exceptions to that rule. The one I want to talk about today comes from OCGA 9-3-99. And what that code section says, you can find it on Google too, is that when a criminal charges arose from an event or could have arisen from an event, then the statute of limitation is told, that means paused, until that conviction is terminated, but no more than 6 years. So if someone could have been charged criminally in an event, then that pauses the statute of limitations, the running of the statute of limitations, until that conviction is final, or until 6 years, whichever is shorter. So told there is the language you'll see in the statute. That really just means pause. So to use a couple of examples here, in an apartment shooting case, sometimes the person who pulls the trigger is the one prosecuted. Usually law enforcement will ignore the property owner, but sometimes in the civil world, if the property owner didn't provide the level of security that they could have, that property owner can be held responsible for that security failure. In that context, let's say that a shooting happens on January the 1st of 2017. Well, normally that statute of limitations, that 2-year statute of limitations for personal injury, would run or expire on January 1, 2019. But let's say the shooter and the person who pulled the trigger was prosecuted, and that prosecution took a year to finalize. Well, in that case, under OCGA 9-3-99, the statute of limitations was told for that first year because the criminal proceedings were ongoing, which means it basically didn't run. So the statute of limitations didn't actually start running until 1 year after the shooting, when the criminal conviction was filed on January 1, 2018. And that would mean that the statute of limitations didn't expire until January 1 of 2020. That rule applies not only to the shooter, that is to say the statute of limitations is paused or told not only as to the person who pulled the trigger, but also as to other parties to the case, including the landowner. And the case saying that was called Harrison against McAfee. It was a decision of the Georgia Court of Appeals in 2016.